objections to hearsay, relevance, 403, whether relevant evidence is substantially outweighed by the probative value of relative evidence is substantially outweighed by the unfair prejudice to either party who's objecting, and all those things that the attorneys are well versed in. So for that reason, it is not a good idea to represent yourself. I know that Mr. Marchese has been appointed as standby counsel, and he is sitting there right now with you, but I do not, there's no such thing as hybrid counsel, so he will not be sitting at the table with you if you are not representing yourself. You can stay there right now, Mr. Marchese. That's all right. I'll move you after.
Let me know when I can jump in.
Okay, all right. Well,
I have some questions about my role as standby counsel.
Okay, and that's not a problem. What I want to establish with Mr. Summers first is whether he intends to continue to represent himself or whether he would like for you to step in and represent him. So we need to cross that bridge first. So again, Mr. Summers, good morning. And now is your opportunity to talk to me.
Yes, Your Honor. Good morning.
Stand up.
Prior to deciding whether or not I would continue to represent myself, I would like to discuss the motion for continuance, if it would be okay with you.
Unfortunately, sir, it's been ruled on. I am not Judge Fuson's appellate court. In fact, one of the things I wanted to let you know is that I have no intention of rehearing anything that was argued before and decided by any of the previous judges. With all due respect to you, I am here to try the case. I have a panel of people who are going to come in here shortly, and we're going to start picking a jury. We may do opening statements this afternoon, but I'm just here to try the case. That doesn't mean that if, in the end, the state prevails and you are convicted, that you won't have ample opportunity to have the appellate court review not only prior decisions made by other judges, but any decisions that I might make during the course of this trial. But the motion to continue, sir, has been denied, and I do not intend to revisit it. I apologize.
Okay. I was only intending to, for the record, state my objection to the summary denial of the motion to suppress the photo lineup, the motion to suppress the in-court identification, and the expedited motion for trial continuance. And if it was permitted, Your Honor, I would amend my motion for a trial continuance with new grounds.
Okay, well, that's a different thing. Let me hear what the new grounds are, but you've perfected the record as to Judge Fuson's ruling on all of those other motions, and that is perfected for future appeal. Yes. But what additional grounds would you like to raise as by way of an amended motion to continue?
Yes, Your Honor. Since I had filed the original motion for a trial, expedited motion for a trial continuance, I received a statement of particulars on August 18th, 2022, as requested on August 10th, 2022. Unfortunately, that statement of particulars from the state does not include the location or the time, and that would be needed for me to prepare a defense and could allow for a potential jury instruction. I also need to explore defense options depending on when and where the superseding charge took place. For example, I would also I could provide photographs of an area and investigate surrounding environments. Fortunately, Your Honor, with that information coming so late, I'm going to be unprepared for that charge. That's charge number 3.
Specifically, which charge? This is amended charge
number 3.
I'm sorry?
Amended charge number 3. It was amended on August 8th.
Kidnapping?
Yes. It was amended on August 8th, 2022, and I requested a statement of particulars on August 10th in hearing. I was provided that statement of particulars on August 18th.
Okay. And so that is the precise issues related to your amended or renewed and amended motion to continue. Is that correct?
That is point 1, yes.
All right. Well, let me go ahead and what is point 2?
Point 2, Your Honor, is I had discovery received on August 12th, 2022. It contains new information on 911 calls and a phone report which needs examined and investigated. The details in the witness report contradictions aviation information supplied by the state, which is directly related to the attempted murder charge number 2. There is also new witness connects the defense position that the victim and the defendant were in communication immediately before the alleged events. The phone report provides new information that refutes statements on record and introduces new witness testimony which should be allowed. I believe this information in total gives the defense cause to redepose witnesses. That is point number 2.
When did you receive this 911 call that you're speaking of?
It's all of the 911 calls. The state was well aware that they were corrupted files from previous discovery. They provided them in court on August 10th. I was not allowed to take them with me from the courtroom, but Mr. Marchese brought them to me on August 12th. I listened to them last week in the law library, and this is the information that I was able to gather from them.
Let me just see if I can get a better understanding of the fact that this case is 5 years old. It's a 2017 case. So what went on in 5 years that there was no understanding of what evidence the state had? I mean, am I missing something here?
Yes, Your Honor. You're missing that I was not in charge of any prior counsel's work or defense strategy. I was only brought pro se in mid-April this year. My first time I received discovery was on June 10th, and the full discovery I received on July 13th, which was primarily in electronic format. So I've only had a couple of months to prepare defense for these extremely complex charges. I should not be held accountable for what prior counsel did or did not do. That's their defense strategy. I have my own.
Yeah, but see, I just don't know. I mean, then under that theory, every time I had a trial, and on the morning of trial, a represented defendant decides that he wants to represent himself, you're suggesting that they would be entitled to a continuance so that they can go back and do things, and it just doesn't happen that way. There's not any appellate decisions that I'm aware of to support that. The timing of your decision to represent yourself is your decision. And you see what I'm saying? That any defendant who came into a courtroom on the morning of trial and said, I want to go pro se, and the court does Ferret and determines that they can, there are disadvantages. There are disadvantages to being pro se. There are disadvantages to the timing of your decision to be pro se. These might be some of those disadvantages. So,
Your Honor, I understand exactly what you're saying. And
okay.
Prior to all deadlines, I filed appropriate motions to prepare my defense. They were denied due to the timing of the trial, and that should not be held against me. My reasons for continuance conform with the cited case laws that both Judge Fuson and myself have cited, which provide the criteria.
Well, I'm familiar with those cases. I mean, I've been a judge for 16 years. I've been in this trial division for almost 5 years. So I like to say I've seen everything. I don't know that that's absolutely true, and I'm not inviting something that I've never seen before. But I'm familiar with the cases. I'm familiar with defendants who are pro se, who want to go pro se, who ultimately decide not to go pro se. So I hate to sound or to say this, but I've been there, done all of that before. But my point is that this case is 5 years old and it needs to be tried. It was thoroughly the discovery and hearings and motions in front of other judges, and it was sent to me to try, and I intend to try it. So I do, though. I am going to give you the utmost respect, and you have been giving me respect, and I appreciate that. Those are all good signs in your ability to continue to represent yourself. So let me just say that I appreciate that. But you've raised some issues, and I'm not going to just summarily deny your renewed motion for continuous. That was point 2. Let me hear the other points.
Yes, Your Honor. I have several more. The orders from the court were received on August 16th, 2022, last week. I have not received any orders from the court prior to that.
Which orders, let's be specific which orders you're talking about, because I think you received the order denying your motion to continue this morning.
I received that this morning, Your Honor, yes. All prior orders from the court, which I depended on to utilize experts and due process service providers, I have received no orders from the court prior to August 16th, 2022. And
when did you decide to represent yourself?
I stood on April 13th, 2022, and I filed 2 motions asking the court to please provide trial court communications so that I could utilize my defense experts. And as a result, Your Honor, the defense is severely prejudiced, for the experts who are crucial to the defense are unable to schedule due to complete the evaluations as approved, let alone testify as due process
Hey,
experts.
let me ask you, I apologize, I don't mean to cut you off, Mr. Summers, because I want to give you ample opportunity. But my recollection is these specific issues regarding experts was raised in your original motion to continue that Judge Fuson denied. Am I incorrect?
No, Your Honor. The issue of not receiving the court orders was not raised in the original.
But there
I will
was
relay
something
it.
about your experts raised in that motion.
Yes, it's been an ongoing issue, Your Honor. I've been trying to get the orders so that my experts could be available to at least complete the evaluation and provide a report for the prosecution, let alone be able to testify in this case.
I also saw that Judge Fuson granted a motion recently of you to obtain transcripts.
Yes, Your Honor. That's another
depositions?
point that I will get to.
All right, let's keep going. Then continue.
I do want to add that not receiving the orders from the court is a violation of Judicial Administration Rule 2.516B2 and 2.516N, along with 2.514B, which require the court to transmit orders to all parties at the time of entry and computation of time is required. That is a denial of my equal protection and equal access to courts, Your Honor, which is are my rights under my 14th Amendment to the U.S. Constitution. The Florida Rule of Appellate Procedure 9.420 also protects inmates' rights for service of documents to and from the courts, which includes computation of time. My delay in receiving the court orders has also interfered with timely production of deposition transcripts, which is what the next point. The court reporters first requested expedited rates due to the orders coming so late. They were filed in July, but they did not come until again last week. We did get the expedited rate order, but now the court reporters are arguing that it shouldn't indicate that I am pro se, although the JAC has recognized the defendant as pro se correctly, and now we need a week to produce transcripts, several of which are key defense witnesses and other for crucial impeachment purposes. These were over almost 30 depositions, Your Honor, that were taken over this summer. We have 0 transcripts from them, and that again was due to the delay of the court issuing the orders for me to get those transcripts. There's also a complication there with the Judicial Administration Commission about how I appear when JAC registered service providers view my information on their portal. That, again, Your Honor, none of these issues, I'll restate, have nothing to do with my faults. An additional point, Your Honor, is that trial subpoenas were refused by the Hillsborough County Sheriff's Office. I've not been provided as a reason with that. And the Sheriff's Office has not responded with my trial subpoena services, so we do not know who we can call for a defense. These are all multiple issues that have come up in the last week, Your Honor.
All issues that I'm sure you were made aware of that are potential, issues of representing yourself and being incarcerated and not being able to do the same things that if you had an attorney outside. They're disadvantages. A lot of these are disadvantages of self-representation. It's unfortunate, but it's just the truth.
Well, it is, Your Honor, with the exception of the rules of what is required by the courts to provide the orders, what's required by the courts to issue documents to and from inmates. I've given you these rules, and that's not because I'm pro se or because I'm indigent or because I'm incarcerated. It's simply a fault of the court that prevented me from having experts here at trial. And as a result, I am severely prejudiced because I will not have experts that I could have used in place of my own testimony. So then it pushes me in a position to where I may have to testify outside of my desire to testify. Because I believe those experts, and I believe that some of the witnesses that I would have called, due to the Sheriff's Office and due to the court's delay, would have sufficed for my testimony. So I'm in a terrible position there, not because of me, and not because of anything that I've done wrong or because of my incarceration, but it's because of circumstances that are outside of my control. Not circumstances I could know of either. These are things that I requested. I've been pushing the courts for multiple issues to get addressed long before we've gotten here today, Your Honor. And if you look at the record, you'll see that I've been diligent in trying to prepare a defense for this
I hear
case.
you, and I have looked at the record. Go ahead. What's your next point?
Your Honor, I just re-allege my expedited motion for trial continuance, and I do point out that I will suffer injustice, prejudice, and denial of due process, and that the only party prejudiced for a fair trial is mine because of these issues right now. And I am requesting you to grant a continuance, and we would be able to do it this year still, but these issues should be able to be resolved so that we can have a fair trial, Your Honor. If not, I would move for another motion to dismiss based on violation of due process rights, and we can discuss that now, or we can discuss that later. It's up to you.
Well, I haven't ruled on your motion, renewed motion to continue. Let me give the state an opportunity to respond to anything new that you've raised. So I want to hear briefly from Ms. Johnson, and then I'll make a ruling, and then we'll see what, based on that ruling, you if anything, need to do. Ms. Johnson?
Good morning, Judge.
Good morning.
First, starting off regarding the statement of particulars, Judge Fuson granted the defendant's statement of particulars regarding count 3. I believe that was on August 8th. Typically, the standard is 10 days to respond. I filed my response on August 16th. Since the defendant represents himself, it's not an automatic receipt of that, so I went ahead and mailed him a copy, and so he apparently received it on the 18th, still in timely manner. Regarding the 911 calls. The 911 calls in this case were provided to defense back in 2017. When the defendant started representing himself, that is the first time I heard from anyone that any disks were correct.
And you agree that was April 13th of this year?
I don't recall the exact date, Judge, to be honest, but he had 5 prior defense counsels, and no one ever contacted me to tell me that any 911 calls were ever correct.
Well, and that may be another issue for another day.
Correct. So I went ahead when the defendant expressed some issues viewing the discovery. My office copied every single disk, every single thumb drive I had in my possession, and provided it to the defendant. The state is not intending on putting forth any aviation evidence in this case. No aviation evidence furthered this investigation anyway. There is no exculpatory evidence in this. Basically, these 911 phone calls, they're communication between dispatch and law enforcement. So that evidence is hearsay and would not even be admissible before the jury.
Well, so you don't intend to introduce any of it. There's the possibility he may try, and you anticipate objecting to him trying to get that information in. Is that what I understand?
Yes, Judge, it's to hearsay. Regarding his issues with the orders and the JAC and transcripts, the state went ahead, even though he is representing himself, the state subpoenaed and set up over 32 Zoom depositions for the defendant to get those done. They were recorded. The defendant was aware of that. The judge, prior to Your Honor, Judge Fuson, set up almost weekly meetings with the defendant to make sure he was getting what he needed and that this case was progressing so that it would be tried this week, since this case is over 5 years old. Judge Fuson made sure that the JAC was present when the defendant voiced concerns about not getting responses from the JAC. Your Honor went ahead and prepared the orders himself rather than having the defendant prepare the orders.
Me or Judge Fuson?
I'm sorry, Judge Fuson prepared the orders himself without having the defendant to have to prepare them and submit them to His Honor to make sure things were done in a timely fashion. He made sure to speak to the clerk's office and to make sure that the defendant was to receive the court orders. Judge Fuson did file those court orders in a very timely fashion as well. Regarding the trial subpoenas and the defendant not getting any of those back, the defendant witnesses were just subpoenaed last week because the subpoenas by him were just prepared. So again, all of these issues that he is highlighting for Your Honor are due to his issues being incarcerated and his choice to represent himself. And the delays and his issues that he is having are caused by nothing other than him being incarcerated and his choosing to go pro se.
All right, thank you, Ms. Johnson. Mr. Summers, I'm going to give. I always give the other side an opportunity to respond to him, but I have a couple of questions that I'd like answered based on what the state has told me. Let me just go back to and confirm that it was April 3rd of this year that you began to represent yourself.
Your Honor, it was April 13th.
13th. I can't read my own handwriting.
Yes.
April 13th. Is that correct?
April 13th, and I filed my motions. We were scheduled for March 18th was the first potential hearing date for those motions, but the first time I was able to hear my motions was June 1st. I requested discovery, and the first time I started to receive discovery was on June 10th, which was in paper format, some of it from Mr. Marchese. The rest of it I was not able to receive. Mr. Marchese brought it to the jail in electronic format, but the jail would not allow it to be accepted.
And I think you alleged that in your original motion, because I read your motion to continue that Judge Fuson ruled on, and some of the things that you are telling me I've heard before, and I the only way I could have heard from them is from your pro se motions that you filed in this case. Is that correct? You did mention these things about the jail not allowing you and all that. So those are things that Judge Fuson was aware of when he denied it. But on April 13th, when you decided to represent yourself, did you know that this case was set for trial today?
Yes, Your Honor. I did know it was set for trial for today.
Okay. Did you not send out the subpoenas like Ms. Johnson has just reported to the court until last week?
Provided the subpoenas on August 11th to my investigators. They delivered them to the
So that
sheriff's
was
office.
11 days. Today's the 22nd. So you provided subpoenas to your detective for today's trial date 11 days before the beginning of the trial. Is that correct?
Yes, Your Honor. That's
Okay.
correct.
You heard what she said about, I know you raised some issues in one of your points regarding some aviation evidence, also some dispatch stuff that the state has indicated they have no intention in their case of chief of even bringing into evidence. What is your position on that? You intend to bring that evidence in during the defense
Yes,
case?
Your Honor. If I was given the time to complete that discovery and to explore those specific things, especially the aviation, Your Honor, because the aviation was used. We have testimony from a Sergeant Harrison Bashner that there was a aviation unit on scene at the time of my arrest and just prior to the time of my arrest. And just prior to the time of my arrest is the exact same time frame that I'm charged with attempted murder with a rope. And if there's some kind of testimony, whether from a pilot or from the cameras that were on that aviation unit, we should have the opportunity to explore that. We should be able to see if there was something that would negate the guilt of the accused due to that. And in addition to that, Your Honor, the 911 calls also revealed that aviation units were on scene at the times of the alleged charge.
All right.
And in addition to that, Your Honor, the response I received by email from Ms. Johnson was that it was only used for a prior search and there's no further information. That's fine, but I should be allowed to explore that now that I know for certain that aviation units were on scene at the time of the alleged crime.
All right. I hear you, Mr. Summers. Let me say, not that it matters, but you are very well spoken. You appear to be very intelligent, very prepared today. You've cited rules, judicial rules, and evidence rules. I've considered all of the amended information that you have added this morning for a continuance, and I'm going to deny that request for a continuance at this time. So we're going to go to trial today. Now, what I need to, I've allowed and accepted your decision to represent yourself, but now that we are about to start a trial, I want to make sure that it is your free and voluntary, informed, intelligent decision to continue to represent yourself through the trial process. So as I've said before, I do not know what your level of education is. I suspect that it is probably very high. Can you go ahead and just tell me what your level of education is?
I've just finished some college, Your Honor. That's as far
So
as
you have college, and obviously you can read and write.
Yes.
And do you have ever been diagnosed with any mental health issues that would affect your ability to represent yourself?
No, Your Honor, and I apologize, but may I please have my objection to your ruling on my motion for...
Oh, absolutely. Yeah, you want to preserve the objection to the... yeah, absolutely.
Yes, I would. And would you like me to raise the other motion for dismissal
What was
now?
the other motion?
I
The motion. You're right. I apologize. You said depending on how I rule on your motion to continue, you may have a motion to dismiss. Yes, we need to address that. And you do still want to represent yourself at least for that additional motion. Is that correct?
Yes, please.
All right, go ahead.
Your Honor, yes, I would renew or ask for reconsideration, I should say, of my motion to dismiss.
Well, let me stop you for a moment. Reconsideration. Did Judge Fuson specifically rule on this motion?
He specifically ruled on a written motion, and I'm making an oral argument now, an oral motion.
To dismiss.
Yes.
All right, go ahead.
The oral motion I'm making, Your Honor, is the motion to dismiss based on Criminal Procedure Chapter 94, pretrial motions, Section 9430, motion to dismiss, violation of due process rights. I re-allege my prior claims, Your Honor, that I was denied equal protection, equal access to the courts. I've also had due process violations by not being able to test the evidence that is against me, so that I could have evidence or proof that I could refute any of the charges against me. And additionally, Your Honor, in Chapter 94, the state is required to file a traverse contesting the facts, and they did not, and so therefore those facts are deemed admitted. So I ask you, Your Honor, to please consider my motion dismissed based on these simple, very simple rules.
All right, I hear you. I understand you. And with all due respect, I'm going to deny it. And those are all perfected for the appellate record. It sounds like, at least in your mind, you have some very good issues on appeal. You may or you may not. But I am going to deny it. I am going to accept all the prior rulings by Judge Fuson and any other judges who may have been in this case. So thank you. Now let's go to, we are going to start it again now. We are going to start a trial.
Respectfully, I object. I'd like my objection stated on the record.
Absolutely, and I'm not offended by it in any way.
Thank you.
So you are welcome to do that. So now the issue is whether you're going to continue to represent yourself during the trial. I asked you already a couple of questions. I've indicated to you from the very beginning that it is not advisable. It's not advisable because there are specific rules. You are familiar with a lot of rules. Let me tell you that. But I don't know how familiar you are with the rules of evidence. Chapter 90 in the Florida statutes that deal with a variety of things, as I previously alluded to. 403 is relevant. 401 is relevant evidence. 403 is relevant evidence can be excluded if the prejudicial effect of that relevant evidence substantially outweighs the probative value of that evidence. Those are things that come up in trials all the time. 801 is hearsay. Hearsay, I'm sure you know because you are intelligent, is an out-of-court statement. There's more to it than that, though. That's not the simple definition. The definition is an out-of-court statement being offered to prove the truth of the matter asserted. And that's what we often have a lot of litigation over as to whether it's hearsay or not. Yes, it's an out-of-court statement. That's the easy determination. But the more difficult determination is it being offered to prove the truth of the matter asserted, or is it being offered for some other purpose? If it's not being offered to prove the truth of the matter asserted in the statement, then it's not hearsay, and it is admissible unless it's precluded by some other rule, including Rule 403, that its effect is substantially outweighed by the danger of unfair prejudice. Other than that, though, if it is hearsay, do you know how many exceptions there are in the Florida Evidence Code for statements that are in fact hearsay but are still admissible in court?
Roughly 30, yes.
You're right. It's 28. And there's another provision that distinguishes between different things related to those exceptions. So, all right, well, let me see if there's anything else I want to go over with you then. Do you want to continue to represent yourself?
Your Honor, just due to the fact that I'm unable to have the evidence that I've requested and due process.
And all those things are preserved for appeal. So even if you're represented, those things are preserved for appeal.
I understand that, Your Honor, and I do have 2 pending petitions with the second DCA right now.
I heard, but they did not grant any stay of your trial.
Correct.
Okay.
I'm still following through on them. And with Mr. Marchese not being able to be at counsel table with me to confer, for me to ask
Yeah,
them.
and you know what? I'll explain that even more. That in Florida there are rules that say that pro se is not there's no such thing as hybrid representation in Florida. So it's either all you or all your attorney. Now, obviously, you'll be able to communicate with your attorney if you have an attorney representing you. But I do not. I've had plenty of these, and I do not let standby counsel sit at the table with you. I want them in the courtroom so that at some point, because there's always the chance that if you continue pro se, you may at some point say, I want representation. And that's why we have standby counsel, so that they're aware of the proceedings, they've been in the courtroom, and they can step in at any time. The other way that somebody might have to step in, and I don't anticipate that at all. Let me say, you have been respectful, and I don't anticipate this at all. But sometimes defendants get disruptive, pro se defendants get disruptive, and I will warn them, but if they continue to be disruptive, then I will make a decision that they can no longer continue to represent themselves. That's happened before. I don't anticipate that happening here, but that's the other reason we have standby counsel in the courtroom. But they cannot consult with you if you're representing yourself.
I understand your position. Thank you.
Mr. Marchese, it sounds like you want to be heard before I hear from Mr. Summers as to his final decision.
Yes, sir. Apparently it's become very critical with Mr. Summers to make this decision about whether he represents himself or whether he is turning it over to me.
Imagine, it's a tough decision.
Well, and that's where we are. So now I've done this work. I've never been standby counsel before, so I've done some research in all this. And yes, I'm standby to be in the courtroom because I have to be aware of what's going on. And any time that he says I've got to step in.
That's correct. That is my intention of having standby counsel.
All right, but I consider myself then an understudy who has to jump in any time. All right, but that's what I'm reading from the case law now, and I am quoting from Behr, B-E-H-R versus Bell at 665 Southern 2nd, 1055. I'm also quoting from Jones versus State at 449 Southern 2nd, 253.
Same quote from both cases?
I'm sorry?
Same quote from both cases or different
pretty much
quotes?
close by. I mean, they both say on Behr versus Bell, the quote is the trial court should reserve the appointment of standby counsel for the limited circumstances where such action is necessary to preserve orderly and timely proceedings.
Okay.
Jones v. State says that the standby counsel is to assist and help assist the defendant, but you're right, I'm not a hybrid counsel. He doesn't jump in or jump out, but I am here to assist and advise. I'm also quoting from Barnes versus State at 29 Southern 3rd, located at page 1010.
The rest of that case says that the defendant has the entire responsibility for his defense, if you read.
That's exactly right. He has the entire responsibility for his defense. I'm not here to object or to make anything, or I'm not his second counsel. I'm not co-counsel.
Are you requesting to sit with him if he decides to represent himself?
I'm requesting to be at counsel table or close by for him to be, because what I've got, and I'm quoting Barnes now, standby counsel may participate in the trial proceedings as long as the participation does not seriously undermine the appearance before the jury that the defendant is representing himself. The way I see this, and I kind of narrowed it down to, he can ask me a question, and I need to be available to him to answer that question, and that means close by. Apparently, I'm not allowed to solicit to him, stand up, object, hearsay, you should object. I admit that I'm not doing that, and as you've seen here, I don't get involved in the conversation. But I should be available for him to turn and ask me a question, just procedurally, get him to stand or sit, or who goes first. I spent a lot of time with him in the jail, going through voir dire, going through cross-examination, going through the rules of hearsay, how to pick a jury, how to cross-examine witnesses and things like that. And I think he's pretty good. As you see, he's intelligent.
But the requirement that I appoint standby counsel, so who would be giving him that advice if I did not appoint standby counsel and allowed him to represent himself?
Well, I guess that comes down to the question of whether he's going to represent himself. And that's my conversations with him, is that his decision now is going to be dependent upon how my proximity to him.
Well, I will tell you, you're not going to sit on this side. I never have let standby counsel sit on this side of the bar, so you would be seated in the first row behind him. as to whether I would allow him to ask you questions. What do you think about that? What? The issue there is whether it is impeding the proceedings where, every 5 seconds he wants to turn around and ask you a question. I imagine that in an abundance of caution to the cases that you cited, that certainly while we take breaks, maybe if there is occasional reason to take a break so that he can consult with you, that I would allow it to some degree, as long as it does not interfere with the orderly process of the proceedings. That will be my ruling. Now, I don't think that it's in his best interest in front of the jury, who he's been told, and we have an instruction we have to go over to the jury if he decides to represent himself, to be leaning over the railing. So my decision on this, as I said, it will be mostly outside the presence of the jury. I think is also, hopefully, for the record, in his best interest than to allow him to be continually leaning over. And I don't know or anticipate that that's exactly what he would do, but I'm going to have some ground rules, so to speak, as to how. And absolutely, you're right about you cannot, tell him, hey, I need to talk to you. Don't do this. Don't do that. But I'm sure that we can reach some reasonable accommodation as long as it doesn't interfere with the orderly process of these proceedings. But you will not be sitting on this side of the bar if you're not officially representing him.
Well, that's exactly what I want to challenge with you. I understand you don't want me at counsel table. I do want to be able to converse with him. I'm going to respectfully suggest I be allowed to sit this side. I am an officer of the court, to allow me to sit this close so that it would not be so obtrusive for him to lean back. I'm back at that bench. For the record, I'm asking for a distance of 2 feet, and above the rail maybe another 2 or 3 feet. So it's a difference of a few feet, but it would be the difference between whether he could just simply turn over and ask me a question, is this proper, is that not proper, versus maybe having to even get out of his chair and me having to lean over, which would be much more disruptive than him simply turning around to simply ask.
Specifically, what authority, Jones, which case are you relying on for this 2-foot rule?
Well, I don't know about 2-foot rule. What I'm reading in Jones' case is also embarrassed that everything you said is absolutely correct. He is not hybrid counsel. We can't tag in and tag out. He can't make choices. Once he makes one choice, it goes. And I'm not co-counsel. I cannot help him I cannot give him unsolicited advice. I guess that's the way I'll distinguish it. But under these cases that I'm reading, I think I am here not only to step in the event he decides that he no longer represents, but I am here to provide advice to him. I can't do that from beyond the rail.
Where is that entitlement, though? If I don't have to, if I'm not required to provide standby counsel to a pro se defendant, where is that right to consult with standby counsel if I appoint standby counsel? Where does that come from? You would agree with me, right? That I don't have to provide standby counsel. And under those circumstances, he would have no one that he could consult with or ask questions to. And if I can do that, if you agree that I can do that, then he has no right to consult with. You're telling me that if I appoint you, and you're already appointed, and I allow you to continue as standby counsel, then he should be allowed to consult with you. And that, in my mind, is hybrid representation that the Supreme Court of Florida has specifically said is not allowed in the state of Florida. So, with all due respect to you, it is denied. You will sit outside of the bar. If he wants to talk to you, I'll take a break and let him talk to you as long as it doesn't upset the orderly process of these proceedings. It's perfected for the record, and if that affects his decision that he's about to make, he certainly can include that in any appellate argument that he has, that I denied your request to sit within 2 feet and to be there for him to lean over and ask you questions throughout the course of the trial, which, for the record, I think is hybrid representation. Thank you, Mr. Marchese. Mr. Summers, what do you want to do?
Yes, Your Honor, I understand your position. I agree with you. And
Thank you. Someone does. That's a start.
Let's see where we go.
I would respectfully yield my case to Mr. Marchese,
Excellent.
and
That's a wise decision. Let me ask you a couple of questions before I hear from Mr. Marchese. Has anyone forced you or threatened you in any way to make this decision?
no, Your Honor.
Are you under the influence of any drugs, alcohol, or prescription medications that may in any way affect your ability to freely and voluntarily decide that you have elected to have Mr. Marchese represent you through the course of this trial from this point forward?
No, Your Honor.
Thank you very much. You may sit down. Mr. Marchese, you are the attorney on this case. What would you like to say?
Boy. Your Honor, I'm...
Welcome aboard.
Yeah, but this is an absolute dilemma. I'm going to start from the very beginning.
Oh, yeah. Go ahead.
This case started 2017. That's why we're 5 years later. I didn't get in it until 2020. He had two private attorneys, public defender's office, and regional counsel. Public defender, regional counsel withdrew fairly quickly. His two lawyers originally came in, did a suppression hearing, which the judge denied. He made a statement, which will be able to come in.
Wait, say that again. When was that? What was the date of that? You said 20?
I came in 2020.
Oh, okay.
Really in February or March, right as the pandemic hit. The jail was shut down.
I'm
It
aware
took
of that.
over a year
I'm aware of that.
just for me to get in to see and meet with Mr. Summers. So we never really established a rapport with them, nor did we ever get together on what exactly would be the defense strategy. He and I had numerous problems throughout my representation. I must have filed 3 or 4 motions to withdraw. Mr. Summers must have filed 3 or 4 motions to kick me off. We went through this with Judge Kaiser. Finally, Mr. Summers asked me to have Judge Kaiser recused. We did. We went again before Judge Polo. Same motions, same denials. We were set for trial in December before Judge Polo. Then we didn't hit the schedule for Judge Polo. We came to you, and you gave us this trial date for August. Then in December, and I was arguing to withdraw from this case back in November of 2021 when we were set for December. I think I even filed even August, maybe this time last year, for a November trial date. Then when the case came to set for August, in January, February, again, I was filing motions to withdraw. He's filing motions to get rid of me.
Those motions were all ruled on, I suspect?
They were all ruled on, of course, and they were denied. He has appellate motions on those. Those are still pending.
Understand.
So upon the denial of withdrawing the counsel, and again, he's a gentleman, and he's an intelligent, respectful man. But we get some heated arguments on what is the trial strategy, what is our strategy, what type of defense we have. To the extent that he never agreed with me about any of it. On the attempted murder, I had filed a motion for an affirmative defense of abandonment, abandonment of purpose, the allegations with a rope or with a pillow, and that he stopped.
As to which charge was the
To
abandonment?
attempted murder.
Attempted.
One count is charged with a pillow, the second count is with a rope. The evidence, I believe, shows that he stopped each time, warranting the defense. He didn't want the defense, and so one of the things he did, as soon as he became his attorney, was he struck the affirmative defense of abandonment. And so this is just an example of how we've disagreed with each other. All right, so now he's represented himself. He's done all these witnesses, which I disagree with. He's done a lot of motions, which I don't really agree with again. And we're here to try what is his case. Once he did that, and he's told you, as soon as things came to me, I immediately ran to the jail. He has all the materials. He has the external hard drives. He has all of the disks. He has all of the transcripts of what we have. We still have a number of transcripts that have not been printed. I'm dealing with both Mills and reliable reporting, and either the order came back at a standard rate when now they want an expedited rate, which now they've done, but the JAC is still messed up in what is listed in this case. According to the court reporters, I'm still listed as counsel, so they will not accept an order for an expedited transcripts if it says pro se, which it does. We're here on the day of trial. We don't have transcripts. I'm not in a position, as I've been doing this for 4 decades. I'm always prepared for trial. My files are in order. Everything's ready. You call the witness. I have everything I need on that particular witness. I have nothing. I don't have any hard drive. I don't have the disk. I don't have any information. I don't have any of it. I have prepared for voir dire, expecting this. I'm ready to do that. I've talked to him about selecting a jury. I'm going to come back to the 2 feet rule, because it comes down to Mr. Summers is prepared to try the case he wants to try if he simply allows me to be available to answer what
have hybrid counsel. Say it. So he's prepared if I allow hybrid counsel, which the Supreme Court has said that there is no such thing in the state of Florida.
I agree, and I don't want to be hybrid counsel. I know what hybrid counsel is, and I'm not going to be.
It walks like a duck. It talks like a duck. It must be a duck.
Hybrid counsel is assisting the different, and again, I'm breaking it down to whether it's solicited or unsolicited questions. I think he ought to be able to ask solicited questions and be able to get to me. And let me answer a quick question. Just like it wouldn't be inconvenient for someone to be able to talk, whether it's an investigator sitting next to him or someone else.
I've already ruled on that. I'm not changing my mind.
But if the proximity is the issue to allow him to represent himself, he's in a better position to try this case. I am not. If that's where you are, then I'm in a position to make another oral motion for a continuance myself.
Let me hear it.
Again,
I am not allowing hybrid counsel. So if you are the attorney now, and if you are trained in the rules, you have a lot of experience, and if you want to make a motion, you are welcome to do so.
That's what I'm doing. I will now make a motion as his counsel, I guess. I'm going to ask for a short continuance to be able to put my files together, gather them from him. I don't even know if they're here. I've been asking all morning if our hard drive is here. I don't even know. I don't know. I'd like to be able to get this ruling decided. The court reporters need a decision about whether the JAC considers it an attorney case or a pro se case. But if not, if it's an attorney case, I can call them, but I got to change the order. The order granting the transcripts has to be changed so that I can get those transcripts. And I need those transcripts, Your Honor. I've been doing this for 4 decades. I work on paper. A lot of the young lawyers all use computers. I work from paper, and I usually have depots and transcripts and police reports and everything, and I highlight and notate and document. I don't have any of that.
I hear you. All right. Anything else related to your motion to continue?
I want to revert back to any other consideration that would be amenable. I mean, maybe it is seeing behind that lets me sit 2 feet or 3 feet, but allows him to come to conversation with him, because I know the case he wants to try is not the case I want to try. Not the case I would try. And again, for appellate purposes, I've been screaming this from the beginning. I see this train wreck happening. I see this all coming back. He wants to try the case, some accommodation about this one issue. I will never be hybrid counsel. I know what that is. But I should be able to answer his solicited questions even in the presence of the judge.
I hear you. I understand you. Any previous decisions that may be a train wreck for appellate purposes are not mine, but I take full responsibility for my decision to not allow what I perceive to be hybrid counsel. I'm not changing my mind on that. I hear you and all the reasons why you're not ready. Ms. Johnson stood up, so it looks like she wants to briefly be heard related to the motion to continue.
Judge, this case has been set for trial since 2021. Defense counsel has known for quite some time that he
I
was...
suspect that you're going to argue against his motion to continue. Is that correct?
I
You're
am.
not going to concede it at this time, are you?
No, Judge.
Then you don't need to see anything else that's denied. All right, so jury selection is next. And we have, I believe, 50 people that we're going to bring in first. Unfortunately, our courtroom, am I wrong?
I'm sorry, I was making sure it's
50 people that we're going to bring in. 60 people. See, I was wrong. I do make mistakes. Well, I was overruled already. 60 people we're going to bring in. It does take up a majority of the courtroom. So I see a lot of people in here. A lot of times we make provisions where some people can sit over here when we're using up the courtroom as far as spectators. Also, there's a number of things we're going to have to go over with the group regarding all this equipment that's in here, and that should not influence them. They should disregard the media. We're going to need a statement that I can read to them, because one of the first things I'm going to do with the 60 people, my intention is to go over conflicts, to go over prior knowledge of the case. Because of the media attention, my experience with these types of cases is that several people will have heard about, read about, know about the case, and we need to deal with them. That's going to take some time with 60 people. Then, if there's anybody who we determine should be dismissed for cause during that initial process, then I will backfill those 60 seats. My intention is, when we start the process, to have a pure panel and have eliminated those most likely reasons for cause. Conflicts because of time, prior knowledge of the case, medical issues, conditions, appointments, scheduling conflicts. And backfill anybody who we excuse. Then we will start the process where the state goes first, the defense goes next, then they will all be excused, and we will go over. We will select 6 members of the jury in this case. Is it 12?
I believe this is a punishment by life.
PBL,
If it's to be punishable by life, we get 10.
Well, you get 12 jurors. 6 jurors, 10. I hadn't got to the peremptory challenges.
Can I pause?
Yes.
May I have a 5-minute continuance to speak with my client about his decision? There are 2 totally different versions of what the defense theory is.
Absolutely, but if he was to change his mind to go back, one of the questions I'm going to have him is whether he was forced or threatened in any way to make a decision to go back. But, that's a reasonable request. Mr. Marchese, as unreasonable as I may seem, I assure you that I am not. No disrespect to any other judges here, but I am one of the most reasonable judges you will try a case in front of. I am assured of that. I will give you 5 minutes.
I've been in front of you many
We'll be
times.
in recess for 5 minutes.
Neither will I go in with a rubber mallet either.
We'll be in recess for 5 minutes. Thank you. You asked for a 5-minute break. I took a little longer. I apologize. Sergeant, did you have something?
Just 1 second.
Yeah. Mr. Marchese.
Yes, Your Honor. We did take a break. I walked through with Mr. Summers again his decision about self-representation or me representing. I'm announced to Mr. Summers and the court. He and I have totally different theories about this case. Totally different. He has still decided not to represent himself.
I think that's a wise decision.
Him. It does pose a number of dilemmas for me. One is, again, I'm going to come back to the order for the court reporters. Judge Fuson recently gave a recent order, I think Friday or Thursday may have done it, that granted expedited transcripts. But the court reporters still won't do it because they still said that the order says pro se. They consider at the JAC that he's not pro se, that he's still under my control. So now that I'm back as counsel, I'm going to ask for another order that I submit to you.
Absolutely. Let's get that signed as soon as possible.
I'm going to get to my office to prepare that, or I'm going to call my office to prepare it.
Who are the court reporters that...
Reliable and Mills.
Okay. State, no objection to that, right?
No objection.
Yeah. I want to get an expedited order telling them ASAP as soon as, and I will also, now that you have been brought in, promise you that we're not doing opening statements today. So we won't start the trial till tomorrow. If there's any need for some lags or delays in order to accommodate you, I mean, within reason, but delays to get depots, I'll ask the state. State, I can't require you to do this, but if you can let the defense know what witnesses you intend to call first so that they can ask that those depositions be transcribed first so that you understand where I'm going with that.
The order that I filed my witness list in, that's what we anticipate how the order is
Excellent.
going to
The
be.
state doesn't always do that. You don't have to do that. I greatly appreciate that. Also, if there's anyone, sometimes, I'm not suggesting that's the case here, sometimes there's a list that's a lot longer than you intend to call. So if there's any ability to let them know there's somebody on there you don't intend to call, let them know so that they can put that there. They're still welcome to get those depositions if they wish. But they can, the idea is prioritizing at what depots are transcribed so that they can be ready.
Absolutely, Judge.
Thank you. I appreciate you working with them on that. And I had no doubt that you would.
Well, if we start out with Ram Crosby, I already have his depositions. I'm okay there. Some of the others. I want to mention one lady that we both spoke about. There is a witness who's both on the state and defense witness list whose name is Kimberly Shea. She's a civilian. She is a college student. Her mother called me and told me that she is on her way to Penn State.
Uh-oh.
And I think that the state and I were talking in terms of having her testify by Zoom.
I will allow it.
Okay, so now I have 100 questions. If you're going to call her, then I don't necessarily have to worry about it. But if she's not going to call her, and now my witness, I have no idea of what is my responsibility. Do I have to get the Zoom link? Do I have
The
to
good news is that if you're going to have to call her, it won't be until later in
Right.
the week. And we will absolutely assist you. We've done it before, and assist you in how there's some equipment they need to roll in here. But the important thing is that the witness be able to see the defendant. There was a recent Supreme Court case that was reversed because the witness who appeared on Zoom could not see the defendant in the courtroom. So we know what's required of that type of appearance, and we will make sure that all of those requirements of the courts are met. Now, I do think that we have to go through court administration in order to have the equipment brought up, but we will assist you in that in every way that we can, both the state and or the defense, whoever's going to call a witness remotely.
Well,
I anticipate she'll be tomorrow.
Well, then you're going to call her.
you're going to call her?
I plan on
All
calling
right,
her,
then
Judge.
you need to make the arrangements, and we will help you in getting whatever is necessary for the Zoom link hookup. We just did it in a trial last week or the week before. My staff attorney and my judicial assistant, I will ask them to provide assistance to you in that.
Yes, Your Honor, thank you.
You're welcome. Next.
Would be the state's motion in limine?
Oh, yes. I reviewed it. Most of it's pretty standard. What's your position? Do you agree? Let me find it. State of Florida's fourth motion in limine, correct?
Yes, Judge.
There's five specific requests.
Yes, Judge, and some of it deals with what's incorporated in the defendant's recorded confession. And so now that Mr. Marchese is taking over, I do need to go through that.
Well, and I'll ask that you all continue to work together on stuff. You know, a lot of times the defense and the state are able to make agreements regarding redactions on recordings. So at least on that one, I may allow you all to talk and see if there's any agreements you can make. If there isn't, and I need to decide something, I will. I have no problem staying late every night so that we make decisions. I know that you need those decisions usually a day before so that your IT people can do them. So I'm willing to do that. In fact, we'll have some breaks today, I anticipate. We might even get a jury before 5 o'clock and then give you all some time. And as I said, I will remain available if you need me to rule on any redactions this evening. I'll stay as long as we need to. But Mr. Marchese, in looking at the 5 requests, are there any that you see that you don't oppose?
Yes.
I suspected so.
We agree with number 1.
So 1 is granted.
Yeah, certainly. We agree with number 2.
2 is granted.
We agree with number 4.
4 is granted.
Just little questions about what exactly would be self-serving hearsay.
Well, and just by that, any and all questions or testimony from any witness that would elicit self-serving hearsay. I mean, I grant that that's you know, but there may be, depending on the issue, something that you have to approach the bench and I decide. I mean, generally, self-serving hearsay would be inadmissible. However, when we get to what it is, what the specific statement is, there may be an exception that applies. Agreed?
Yes, Judge.
An admission against interest is a good example.
Okay, and so anything that the rules would normally provide is not granted. We'll just have to do it on an issue-by-issue basis.
Okay. And number 5.
There's a stipulation.
What we know is that this has to do with testimony regarding allegations within a petition for injunction. We agree that the allegations within the petition, in other words, the initial...
This is his petition.
Well, I'm talking about both now, because both the
but their motion is limited, I believe, to his petition.
That's my motion is limited, Judge. Yes.
Okay, so then I'm going to talk about both of them now, because both the alleged victim had an injunction against him. He had an injunction against her.
Okay.
I certainly agree that the allegations in a petition for injunction are hearsay and not admissible.
Okay.
What I would like to be able to say is that they plan on, they have evidence that they are allowed to introduce the injunction itself because he's charged with the crime of violating that injunction.
That's true.
So I agree that injunction comes in.
Right.
But I would argue that the allegations in the petition for injunction, their petition shouldn't come in, just as our allegations for the petition shouldn't come in. We would also say that it should be fair, that should acknowledge that there was also a domestic violence against the victim.
All right, let me hear, Ms. Johnson. I mean, I kind of understand and don't necessarily disagree, at least at this point, with Mr. Marchese on that. I mean, do you assert that there's some different rule that it should apply, or because it's part of the charge that the allegations in the petitioner, not the alleged victim in this case, should be introduced to the jury?
So I can redact that. What is included in the injunction, the petition for the injunction, is the Williams rule evidence. So there was a Williams rule hearing on this case because there was an incident.
I cannot attest to that I've read everything documented in this case, but I have looked at the docket on Jaws, and I did see something related to Williams' rule.
So there was an incident that occurred on February 18th of 2017. So a couple weeks before this incident, the March incident that we're here for the trial. So an incident occurred on February 18th that Williams' rule has been granted that that incident is allowed to be discussed in the
There
case.
testimony regarding that previous incident.
Correct. Now the state has
Judge Fuson ruled on that?
No, that was Judge Kaiser.
Okay.
So obviously the state is limiting it. We were only going to be bringing it in through the defendant's post-Miranda confession. We redacted it from a videotape confession that he made on the victim's phone. I redacted it from a written confession that he wrote in the victim's vehicle, and I can redact it out of the injunction as well. Anything about that?
Okay, what I'll do is I'll ask you to continue to talk about that. You all may be able to reach some resolution. Certainly, it's in the state's best interest to eliminate any potential appellate issues that you don't have to push. Obviously, you know not to invite error, but anything that there's some room on that you can not necessarily concede but agree with the defense, that then eliminates any possibility of appeal of those issues here, not to say that the defense is anyway waiving any of their previous motions regarding Judge Kaiser's decisions or Judge Fuson's decisions.
The one thing I do object to is I don't know how relevant it is at all that the jury know the defendant sought an injunction against the victim after she sought one against him. I don't know how his injunction against her is relevant at all. And so I would object to any reference that he had an injunction against her.
Do you want to talk to that?
Yeah, I mean, the whole situation, and boy, again, I'm at a loss because again, Mr. Summers has a totally different defense theory than I have.
Well,
working on
you're
my
the
defense
attorney,
theory,
so-
working where I am at, I think we have to show this was a estranged husband and wife scenario. They were not divorced at the time. They're still married. They're having conflict between them.
Established through a number of witnesses.
Why? Well, there's conversations between them and things happening between them. He seeks an injunction against her. She seeks an injunction against him. They both have injunctions against each other. I think that that's relevant to show the situation.
Here's the thing. I don't know. I'm not going to prejudge this. I want to see how it comes up. But I can anticipate that if she testifies, and I don't know. I haven't even looked at the witness list. I suspect she'll testify. But if she testifies and he gets to cross-examine her, that might become relevant in some way related to credibility, which is always relevant. So that's where my thought is going. But certainly not to become a highlight of either. You don't want it in. You don't want to highlight your case, but a highlight of their case. But a simple question regarding whether the defendant sought an injunction against her, if she's testifying, might be relevant to her credibility.
So if the state's limiting the facts and circumstances surrounding Ms. Summers' injunction, we would ask the same be, that request made of the defense as well.
And
the facts and
I think he's
circumstances.
agreeable to that.
Well, I agree. The only thing I want to mention is that there was also an injunction he had on her.
Simple.
Without facts, without allegations, that's it.
Okay,
And
absolutely.
then that's not even with us introducing the injunctive relief. We don't need
Understand.
it. She needs it. She has it to introduce hers.
Okay.
She's at it. Right.
Okay,
The
but
next one is
again,
paragraph-
I'm not making a ruling that it has to come about.
Right.
Things need to play out. And the example that I gave, if she's a witness on the stand and her credibility is at issue, and you intend to do it for that purpose, I would find it relevant. But we're not there yet. But I appreciate the concessions that you've made and acknowledge that you don't intend to introduce. That the only thing you would intend to do under those circumstances is ask a single, simple question about whether he had elicited an injunction against her. It may, and I don't know. I cannot guess at this point whether he will testify or not, and whether it might be relevant somehow, some way, when and if he testifies.
Okay. Number 3 deals with the rape shield law, and of
I'm sorry,
course.
so can we just go back? So is number 5
sorry.
granted at this point or reserve ruling?
I think it's grant. Let me any and all questions or testimony regarding allegations stated in defendant's petition for injunction. Yeah, because that's allegations, and the fact that one was filed is separate. Yes, 5 is granted.
I agree. Now we go to number 3. This deals with the rape shield law. Certainly on A and maybe C, we would agree.
A and C are granted.
A and C. On B, they're in the middle of this story. At the time of the incident in 2017, she was estranged. The victim was estranged from her husband. She was dating a man by the name of Jeff Matheson. I believe they subsequently married. There were issues involved in text messages between the two of them that we consider to be relevant. And so, yes, under the rape shield situation, we're not trying to say, oh, she was promiscuous, she's dating other people, or other than that, but there are text messages.
Just because they're relevant doesn't mean they're necessarily admissible. There's some other rule that precludes them. Why aren't they hearsay?
Well, again, it could be exception to the hearsay rule. If someone denies, if they deny, then the question has to be, this has to go towards motive and some other stuff that he has to do. But I agree with the motion limine on its face about rape shield law and not mentioning things about it. But I suggest that there are specific situations dealing with a particular boyfriend where text messages may very well be relevant.
I will grant, but reserve as to specific conversations and address them specifically at the point that you intend to. Obviously not in front of the jury, but during a break when we get further in the trial and you have a specific text message that you want to elicit, through whatever, I will address specific text messages at that time.
That's it.
All right. So partially granted. Let's say that. PG. On 3B. 3B is PG. Partially granted. That takes care of all of the state's fourth motion in limine.
Yes, Judge.
Can we pick a jury now?
Yes, I do. The victim does want to be present in the courtroom throughout the trial.
She's
Should we address
entitled
that
under
issue?
the rule of exclusion. It says everyone except the victim. When you exclude it, witnesses can be excluded except for the victim. I mean, I think that's specifically in the statute. Am I incorrect?
Are you talking about when we invoke the rule?
Yeah.
The exclusion?
Yeah.
Because right now the exclusion wouldn't be invoked anyway. So for Dyer, she would be allowed, or anybody would be allowed.
I haven't heard anybody invoke the rule. You're absolutely right. So it's a non-issue. Anybody can be in the courtroom. But once, if the rule is invoked, my belief, and I'll have my staff attorney pull it up just in case I'm wrong, but the rule of invocation excludes the victim from the exclusion, is my understanding. I mean, I don't know.
Okay, so number one is, am I allowed to invoke the rule of sequestration right now?
You are, absolutely.
Well, then I invoke the rule.
Okay.
Okay, so now the question is,
What-
the victim would be allowed to stay. I object, ask that she's, especially during jury selection. I don't know how that would affect the jury. In jury selection, they may or may not know who she is, and then when she takes the bench, oh, that's the victim. I sat next to her.
Okay, I hear you, and I'm going to let you be heard. But let's start with the black letter of the law,
Okay.
which is 90.616, and the title is Exclusion of Witnesses. Subsection D says, in a criminal case, the victim of the crime, the victim's next of kin, the parent or guardian of a minor child victim, or a lawful representative of such person, unless, upon motion, the court determines such person's prejudice to be prejudicial. So that's they're generally allowed unless I determine it's prejudicial. So what's your basis? It sounds like you're making an oral motion at this time to exclude the victim, and I would ask you, the grounds would be that it's prejudicial. Go ahead and you may be heard.
I don't have any more. I don't want to waste the court's time about it. This is black letter law on it. I just consider that in each individual circumstance, especially in a case like this, with serious charges, so many serious charges in collection, that it would just be overly prejudicial.
I hear you. Let me hear the state's response.
Judge, we would also cite to Florida Statute 960.001.
I don't have it in front of me, but go ahead and tell me what it says.
Under Marcy's law, Judge, the victims have a right to be present in the courtroom to ensure that the victim's rights and interests are respected and protected by the law in a manner no less vigorous than protections afforded to criminal defendants and juvenile delinquents. A victim shall have the following specific rights upon request: the right to a reasonable, accurate, and timely notice of, and to be present at all public proceedings involving the criminal conduct, including but not limited to a trial, plea, sentencing, or adjudication, even if the victim will be a witness at the proceeding, notwithstanding any rule to the contrary.
Okay. Clearly, the law is that her mere presence is not prejudicial. Some act, and it's in the state's best interest to talk to her, and I mean no disrespect to her if she's in the courtroom at this time, but certainly it's in the state's best interest to make sure that nothing happens that's prejudicial, because then we're in a situation of a potential mistrial. So her mere presence is anticipated by the rules and will be allowed by me. However, if at any time there is anything, the ever absolute slightest, that could be perceived as prejudicial to the defendant, then I will remove her and I will address any motions the defense may have as to a mistrial that may have been caused by that activity that was prejudicial. That's my ruling. Yes, sir.
Since I'm the one that invoked the rule of exclusion, I have in the courtroom a private investigator who may be a witness. I have to ask him to be excused.
There is some case law that talks about experts not being excluded, but any potential witnesses, it's in the best interest to exclude them from the courtroom. Sir, thank you very much. I have some discovery. And I certainly will allow him to talk to you, but not about your testimony now that the rule has been invoked. You're still working for him, apparently, as an investigator, and you can still communicate with him about that.
Yes, sir.
All right. You just can't be in the courtroom when other stuff happens.
That's fine.
Thank you.
Thank you very much.
Mr. Marchese, anything else?
No, sir.
Oh, you have the names, I'm being told, of the panel of total panel. Let me just make sure I have. This is it. Oh, and my judicial assistant has prepared me a chart. All right. What I want to point out is there's 60.
There's 60.
Well, then there's nobody to backfill. So we're just going to do the 60.
I think there might be some more being held.
Yeah.
You'd have to do it at a break and get the. 'Cause
All right.
once you get the.
Started. It's 11 o'clock. I'd like to get started. And as I said, I do intend to spend some time, probably more time with them than I normally spend because of the media nature of the case. I want to give an instruction to them once they come in that they notice cameras in the courtroom. They are not to be concerned about those cameras, and that those cameras' presence should not in any way influence them or concern them. And then I will ask if there's anybody who thinks that that's a problem for them. We may get some people that raise their hand, and then I'll address with them what their issues are. I may ultimately have to discuss that with the attorneys, depending on what their answers are. I need a very brief statement. You all know that you cannot discuss the facts of the case with them, the panel. I can read the information, but sometimes in media cases, there's not enough information in the information. What we've done in these high-profile cases is we've come up with a 1 or 2 sentence what this case is about, and see if anybody then ask if anybody thinks that they know something, heard something, saw something about this case that is not normally elicited by reading the information. So it's up to you all if you can agree as to such a 1 or 2 sentence thing that I can read to them. You know that during the course of the questioning, you can't go into the facts of the case. So I would let them know that's the only thing they're going to hear about the facts of this case. And as a result of that, does anybody think that they know something about this case? And then we would deal with them individually. I'm not going to ask them what they know about this case in front of the other 59 people, because then the other 59 people would know. So they would come up here, I would turn on the white noise, and we would discuss up here what they know, and allow each side to ask questions at that time of them regarding their prior knowledge of the case. But that's how we're going to begin the process to try to narrow it down and eliminate. I also said I'm going to do conflicts. This case is expected, and let me ask now, are we going to finish on Friday?
I plan on finishing. I think I can wrap by Thursday if things run smoothly.
Okay.
Well then, I mean, if she takes all the way to Thursday, again, this is all so different now because it's entirely different.
I know,
case.
you don't have to keep saying, no offense, but you don't have to keep saying it, I understand.
I think I have to keep saying it because I've never been so unprepared as I am right now to start picking a jury.
I hear you, but it's
I
not,
had
it's
my
not
private
entirely your fault.
investigator just turn over files to me that I haven't seen in weeks.
Okay, but it's not your fault.
Well, here we are. I would not read the entire information. There's so many criminal charges on there, and it doesn't get where we need to go on the media case.
I don't have a problem, Ms. Johnson, unless you for some reason disagree, simply telling them what the charges are, count 1 is, count 2 is, and then reading them a very brief factual statement that the two of you all are able to agree upon, and not reading the rest or the information to the panel. Okay.
Right, I wouldn't have any objection. And again, the purpose is that's what's about. The cases from 2017 has been on the news. Has anybody heard about it? Raise your hand. We'll come to the bench and talk about it.
Right, but I've got to give them something for them to know
Right.
whether they've heard about it.
Right. I just need a little logistics. Is the jury, is the panel outside?
They're in a courtroom.
I need a couple of minutes to call my office to get them to work on that order to get to
Oh,
the...
yes.
And
Yes.
then
If
other-
they can upload it and you can at some point let me know, I will sign it, or I'll keep checking, refreshing my my queue, and as soon as it's there, I will sign it. So, yes, I'll give you that time. In fact, I'm going to give you, I mean, I don't know that the state is ready. State, are you ready for me to bring them in? No. You need time to go over the
Great.
slips. So, I intend to give you at least 30 minutes.
Oh, good.
State, does that sound good?
That sounds wonderful. We
Mr.
can
Marquis,
work
that
on-
sounds good? 30
Yes,
minutes?
Yes, sir.
We're going to be in recess for 30 minutes. Thank you all again for your professionalism and for your ability.
Should we come up with the 2 sentences? Should we
fine,
email it to your JA for her to print out? and have
Sure,
her read it?
absolutely. That'd be great. Oh, also, any preliminary instructions? I mean, there really isn't any preliminary instructions. I intend to read them during this, but before opening statements tomorrow, I want you all to agree on 2.1 and 2.1a, those brief preliminary instructions that I would give before the opening statements.
Ms. Johnson did provide proposed. Did Mr. Marquise get a copy?
You get a copy of the proposed entire set of instructions.
Yes. I have 1 page of a requested defense instruction.
I appreciate all, but it's important that he say yes. Thank you, Mr. Marquis. Yes. All right. Thank you.
I just need to know if I can give it by paper. I would need to upload it or email it or what I need to do with it.
This is the proposed.
Oh,
I have
that's
a-
okay. No. The whole stack.
Oh, I got the whole stack.
Okay.
But
All right.
this
Just
is
want to make
mine.
sure. And that is the.
This is an abandonment instruction on
Okay.
the...
That's a proposed instruction that we will discuss at a charging conference
Right, very
later
good.
on.
Okay.
All right. All right. Thank you all. See you in 30 minutes.